This North Carolina mom is in a lot of trouble. You may remember her. She was arrested on Valentine's Day and charged with 80 sex crime charges. Well, she's back in the spotlight, and not for baking cookies or carpool duty. She's back in the news again, now facing even more charges. I'll walk you through the details. For Law and Crime News, I'm Kennedi Walker. Sara Jean Sellers was arrested in February on 80 counts of child sex crimes, including statutory rape. Now that number has jumped to 90, with 10 new felony charges just added. Court records show Sellers is now charged with 8 counts of third-degree sexual exploitation of a minor and 2 counts of indecent liberties with a child. According to newly obtained documents, these latest charges stem from January 2021, when Sellers allegedly possessed explicit images of a then young teenage boy, identified only by his initials. In North Carolina, third-degree sexual exploitation of a minor means possessing or distributing illegal images of children. That can include storing them on a phone, computer, or more. Even though it's considered the least severe of the state's child pornography laws, it's still a felony, one that could require sex offender registration if convicted. In Sellers' case, court documents allege that she unlawfully and willfully possessed photos of that victim's private area and more. The documents point out that the minor was born in 2006, which would have made him about 15 years old at the time of the alleged incident. The 80 other charges Sellers was charged with stem from incidents in 2018 through 2021 with several alleged victims. According to WWAY, the state revealed that 2 victims were 12 at the time of the alleged sex crimes, which spanned from 2018 and 2019. 2 others, whose ages were not specified, are interviewing with detectives. Sellers was arrested on Valentine's Day for this, which meant instead of spending the holiday of love with her husband of 20-plus years or even her children, she was booked into the Brunswick County Detention Center. Sellers faces 20 counts of statutory rape of a child under the age of 15, 20 counts of indecent liberties with a child, 10 counts of statutory sex offense with a child by an adult, 20 counts of statutory sex offense with a child under 15, and 10 counts of statutory rape of a child by an adult. When she was first charged, her attorney argued for a $400,000 bond, but the judge appointed a $2 million bond instead. Sellers is currently 44 years old. Her defense attorney stated that she has been married for more than 2 decades and has 2 daughters. It's unclear how Sellers knew the reported victims and how the allegations were brought to police. The Brunswick County Sheriff's Office says anyone who has any other information about Sellers' alleged crimes to come forward, which seems to be happening given Sellers' new criminal charges. And joining me to talk more about this is legal expert Sara Robinson. Sara, thank you so much for coming on. Let's dive right in. How does the addition of 10 more charges affect the severity of Sara Jean Sellers' case?
Well, Ms. Sellers' case is already pretty severe. The nature of the allegations that she was previously charged with were sexual in nature. These additional charges just add to that. So one of the things that happens, or one of the things that we expect, is that the prosecution is going to use these new charges as leverage to amplify the exposure that Ms. Sellers may have if she's at all convicted. They can use them to force a plea because now we have additional charges, and her exposure may be more significant due to the nature of these charges. And so what it really is about is the prosecutor using these things as leverage, these 10 additional charges as leverage.
I know a question that I was wondering is if she was already charged with 80 charges, and then do these 10 really make a difference, or, in terms of sentencing or time?
They do and they don't. They don't because, at least what I'm aware of, is the prior charges that she's already facing appear to be more severe than these charges. Those charges allege sexual acts between her and these young boys. And so the nature of those charges are essentially pretty severe. These new allegations, they're based off of alleged photos and things of that they may have recovered in her phone, her being in possession of this sexually explicit content, which is not as severe as actually having a sexual relationship with a minor, but it still matters. And so again, the prosecutor uses these things as leverage a lot of times to either force a plea, or once the trial commences, and what they can do is add these charges. So add them to the original indictment or go and file a superseding indictment against her so that these additional charges will be brought in against her if it makes it to trial as well.
I want to thank Odoo for sponsoring this news package. Odoo is an incredible all-in-one business management software that provides you with a range of applications. One of my favorite Odoo applications is their Projects app. Managing projects can be tough, but with Odoo's Projects app, it truly does not have to be. Do you need a clear timeline? Well, the Gantt view maps out your tasks and helps you stay on track. Prefer a more flexible approach? The Kanban view lets you move tasks easily from to do to done. Or if you like structure, the list view gives you all the details at a glance. Plus, Odoo's comprehensive dashboard keeps you updated on task status, activities, and remaining time, so you're always in control. And with the powerful reporting tools, you can track your project's budget, milestones, and profitability in real time. Odoo Projects app helps you stay organized to meet deadlines and boost productivity. So right now you can get a free 15-day trial of Odoo's all-in-one business solution and see how it can make your life easier. Scan the QR code on your screen or check it out at our link, odoo.com/LC News Project. Can you explain what it means legally for Ms. Sellers that she's facing multiple counts of third-degree sexual exploitation of a minor?
What that means is that she was in possession of content that she knew depicted a sexual photograph or something of that nature of a minor. That she knew that she had that material. She knew that material was indecent, contained visual, graphic body parts, and the allegations here are that she was in possession of photos that showed an erect penis or penis of young boys, and that she had that material in her possession. So that is what that means with regard to that specific charge. Also, to the point, the fact that age, maybe there could have been an argument that she didn't know the age of the individuals in the photos. Unfortunately for her, the lack of knowledge of age is not an excuse.
In this case, how significant is the digital evidence against Sara Jean Sellers, and what legal challenges could arise in using it?
The digital evidence here is pretty significant. And I think we've spoken about this topic before where, however these charges ultimately came about, the likelihood is that there was probably a text relationship or communication between the defendant here and these young boys, which is ultimately how some of the allegations came about. Not only that, but I expect that the prosecution, and in fact they did, seized the phone that she possessed and ultimately found further evidence of a crime, specifically these new additional crimes that allude to her possessing these photos. So digital evidence is going to be key here. It's going to corroborate some of the testimony that we expect to come in from these young boys. Not only that, but there's nothing better than video evidence or photo evidence. The prosecution just has to ensure that it is her phone. They'll have to establish that. Some of the legal challenges that can be made will likely be made is that her defense attorneys are going to argue against whatever search warrant was used to obtain this information. One of the things that often happens is there's a search warrant that is drafted and ultimately done so that they can go into the phone and do what we call a dump of the phone. And as a result of that dump, these items ultimately were discovered.
How does North Carolina law differentiate between first degree, second degree, and third degree sexual exploitation of a minor? Can you explain that for those that don't know?
Yeah, so the third degree exploitation of a minor is essentially having photos that show a minor in some sort of sexually explicit depiction. With regard to second degree, that has to do with the actual distribution of these items. So if you're selling them or if you're soliciting these photos, things of that nature. First degree, which is the most significant charge under the statute, deals with the actual production of this type of content. So having an actual child or a minor in your presence, video recording them, transporting that minor to engage in this sort of activity. So first degree is much more severe, much more expansive under the statute as opposed to third degree. I think that there is an argument to be made here that the factual allegations as they become uncovered. This could actually go under second degree exploitation of a minor, considering that it appears that she received these photos, or at least that's what we think at the moment. So that distribution factor, or that receiving factor, certainly would fit under that statute as well. So we'll see what the prosecution does with that.
What happens if a defendant's defense is that they were unaware of the victim's age at the time of the offense? Because I know that we hear that a lot of times in a lot of these cases. They say, oh, we didn't know, or oh, they appeared to be older, but that doesn't matter, right?
No, there's something in the law, and anybody who's taking criminal law 101 will know ignorance of the law is no excuse. In this particular case, the ignorance or lack of knowledge with respect to the age of these young boys is not an excuse. It is not a defense under these statutes. So that argument cannot be made on her behalf.
And just hypothetically, not saying that this is the situation for this case specifically, but if there was ever a time when, an alleged victim did, withhold the truth about their age, would that count if they told someone, oh, I'm actually 18, oh, I'm actually 19, and they weren't? Would that work, or still it wouldn't matter?
Unfortunately for Ms. Sellers, that would not work. Again, with respect to these charges, the lack of knowledge of the individual's age, even under, misrepresentation from that young person, does not absolve her from the liability. This appears to be some sort, and I don't want to say strict liability, but again, with respect to the age, all that matters is that that person was a minor, and Ms. Sellers was not, and ultimately she, was arrested for the charges, and likelihood is she'll face some sort of conviction.
Is it common for a case to be dismissed in the early stages if the victim's identity remains anonymous, or if the victim decides not to testify?
In the criminal world, not that often. So, with respect to the criminal world, and I know there's a difference between that and civil, and we hear a lot about this in the Diddy cases, for example. But with victims, particularly youth, their name will be as protected as possible during the litigation process, and at any point during the proceedings with this criminal action. The likelihood is that there will be orders of protection, if they have not already, being issued on behalf to protect these young people. They're allegations, of course, but she knows who these young people are, more likely than not. And so, there's going to be the orders of protection there. We're not really going to see the charges get dismissed unless there's another factual issue or legal issue that would raise the question of whether or not the charges should be dismissed. It's not going to be with respect to the anonymity of the young person. Not only that, but these young people, the likelihood is they're not going to have to testify until they see a trial or grand jury proceedings. So there will be certain protections for these young people as this case commences and as it continues forward towards litigation.
How likely is it for Ms. Sellers to face significant jail time if convicted on these charges, considering her prior arrest for similar charges? I know she was just recharged with 10 additional, but before it was 80.
Yeah, Ms. Sellers is looking at significant jail time, and these additional charges are just going to add to that. Now, there will be a question if she pleads, what that plea offer will be, what the time guidelines or her sentence would be, if there can be an agreed upon decision between the district attorney's office and her counsel. So hypothetically, they could say a plea to one with 15 years in State Department of Corrections. Once that happens, we'll dismiss the remaining charges. There will be orders of protections for all of the victims. She will be a sex offender, X, Y, and Z. So that certainly could happen. If this case goes to trial and she's convicted on either all of the charges or some of the charges, then she has the possibility of facing even more significant time. And at that point, and depending on what the statutory provisions read in North Carolina, there is the possibility that she could be sentenced to consecutive time as opposed to concurrent time. So if an individual, say they take a plea or a plea to a number of charges or are found guilty on a number of charges, the judge can run that time concurrent, means the time runs together on both charges. Otherwise, the time will run consecutive. So she's doing back-to-back time. So she could be doing 15 years plus 2 years plus another 2 years, et cetera, for each and every offense that she's been convicted of.
I realize every case is different, but when you see a case like this one, when someone is looking at potentially a lot of jail time and they're being charged, with 90 different charges, does a plea deal make sense? Or if it's going to end up with the same outcome, a person usually takes it to trial and try to fight it?
So I'll answer that in two ways. With a case like this and the significant amount of time that she faces, one of the things as the defense is going to probably say is, well, we don't really have anything to lose by going to trial. If they want, or if they extend this sort of plea offer that includes you spending possibly the rest of your life in jail, or a significant amount of time, 20, 25, 30 years, then what do we really have to lose by litigating this case in court? Because then we get to challenge the evidence step by step. Now, it does make sense for for there to be a plea agreement in this case, considering there are 90 charges. That's a lot of charges, a lot of allegations. Her exposure would be more significant if convicted on all of those charges. Not only that, but for the sake of judicial economy, a 90 count indictment, you're going to be on trial for probably a couple of months. Not only that, but we have these young children coming in to testify. It could possibly re-victimize the children. They get scared as the time comes for them to have to testify in front of a bunch of strangers, including the person who is alleged to have committed certain acts against them. So in those types of cases, in order to not re-victimize the child, to just make this go away, a lot of times a plea offer is extended. And I think in this particular case, that would be something that would be suitable for all parties if they can come to that agreement.
We know one of the charges that Ms. Sellers was charged with was indecent liberties with a child. Can you explain what that entails legally and why is it a serious charge in this case?
Yeah, so indecent liberties essentially is indecent or immoral conduct or items that are in possession of the defendant, and they're used for the defendant's sexual desire. So that's the caveat here, is that it is immoral and ultimately used for the defendant's sexual desire. There's also an age requirement there where the defendant is at least 16 years of age or more, and 5 years or older than the child that would be the complaining witness. But that has to do with immoral conduct and for the purpose of sexual gratification of the defendant.
In terms of sentencing, is Ms. Sellers looking at decades potentially?
Absolutely. With the initial charges that she's been facing, she's already looking at decades in prison. Specifically, again, and I think we initially had an 80 count indictment. Now we've got 90 or 10 additional charges that are added. With some of the new charges that she's facing, she's looking at 36 months in prison, for each count that she's facing. And we know that there are at least 10 here. So that's quite a significant amount of time. That's not inclusive of the time that she's already facing with the initial charges under the 80 count indictment. She's looking at a very long time in prison at this point.
Lastly, we know that you mentioned earlier that there's the potential of victims kind of getting re-victimized during this process if they do take the stand. How are the victims in these cases supported during the legal process, especially in terms of privacy and mental health?
Yeah, so a couple of things. When this case is litigated, and we have a First Amendment right to be privy to the proceedings, freedom of press, so courtrooms are open to the public. One of the things that the judges will do is when they are announcing cases or matters with respect to these charges in an open courtroom with many people, they'll use the initials of the child. They won't use the child's full name. There will also be times where the judge can exercise certain judgments and exclude the cameras or media from the courtroom when that young person is testifying. So there are means of doing it in those ways. Not only that, but most district attorneys' offices, they have what we call victim advocates, and those victim advocates are in place to guide the victim, to make the victim feel safe, to really do a lot of hand holding with the victim to ensure that just mentally they're okay, physically they're okay, that they have everything they need as they prepare to testify at trial. And a lot of times they are just very involved with the family, and ensuring that that child feels as safe and as comfortable as possible through this process.
Great. Well, this is a case that we will definitely be following. Thank you so much, Safa, for coming on today.
Thanks, Kennedi.
The new charges will add $20,000 and $50,000 to Sellers' $2 million bond. Reporting for Law and Crime, I'm Kennedi Walker.